Welcome to Cox Co's GDPR Your Payroll in Their Hands presentation. My name is Tracy Jerram and I'm Business Development Manager here within Cox Co in Bristol. The presentation was initially given to our clients and some prospects in our autumn workshop held in Bristol on the 3rd of October 2017. So the aim of the presentation is to help our clients and prospects understand where we are with our own GDPR project. This may be particularly useful if you are undertaking your own GDPR DPIA assessment and need to know what your suppliers are doing to ensure that they meet regulations from May 2018. So the presentation will cover a brief introduction to GDPR terms. This is primarily geared towards our own particular payroll world rather than your own businesses. We'll cover the GDPR project that we're currently running and our data privacy impact assessment that's taken place, including the risk assessments that we have carried out. We will also then cover the impact on the workflow, and this is particularly has resonance with our clients because it will change the way in which we deliver data to our clients and how we receive it. There is at the end of the presentation a couple of scenarios, right or wrong, which hopefully will help our stakeholders understand what could take place that could be seen as a breach and how to handle that breach within the business. As I said, it's primarily aimed at our own payroll bureau. At the end of the presentation will be our contact information. If you wish to make contact with us and ask us anything in particular, please do. We're always happy to answer questions. Data protection here at Cox Co is obviously nothing new. And GDPR builds on the data protection policies and procedures that we already have in place to protect the data that we hold within the business. Our data protection policy is a working document, which basically means we write down everything that we do and we do what we say, and also it goes through a timed review system. So on a quarterly basis we review the policies which are in place. We make amendments if need be, and if there's any other additional systems which are being implemented at the time, these also go under our data protection policy review cycle. Of course, having a solid data protection plan is good, and ensuring that you do what you say you do is the first step of making sure that you have effective policies and procedures in place. We then decided to make some additional improvements, primarily to make sure that there was a member of the staff that was capable of heading the campaign correctly, and that was myself that was selected, Tracy Jerram. I've undertaken training and carried out the Certified EU GDPR Foundation Certificate. Next year I will be taking the Practitioner Certificate 2018. We then as a business decided that we will head towards ISO 27001, and that will start, or the project will kickstart in Q2 2018. This we felt was a good move to show clients and prospects that we are taking data protection seriously and that we are doing all that we can to ensure that there will not be a breach and that their personal identifiable information that we hold, which obviously is large sums, is well protected within our organisation. While carrying out our research, it became quite apparent there's a number of businesses which advertise that they are GDPR approved. It's important for us to ensure that our clients were aware that there is no GDPR certified company. You can carry ISO, but that doesn't necessarily mean that you are GDPR compliant. You can take training, a person can be trained, a business can have a data protection policy, you can have a solid review and security design principles, but as it stands at the moment, which is October 2017, there is no way of getting your business GDPR certified. So if you see any signs, say an IT governance, HMRC approved, data protection regulation symbols blazoned across websites or literature, then please take that with a pinch of salt. Here we have a brief introduction to GDPR key terms. This is particularly tailored to our own payroll bureau. Firstly, the changes in law. GDPR comes into effect 25th of May 2018. At the moment, that's still 6 months away. It's a regulation, not a directive. Data Protection Act was a directive and was interpreted by each member state of the EU, whereas the regulation is a one-size-fits-all member states, and it cannot be changed by the member states or a particular country that is implementing that regulation across law. It is law for all UK organisations post-Brexit and all EU member states. It also is law for anyone who provides services into the EU and or processes EU citizen data. In our particular instance, data controllers are our clients, and they are accountable for all data that they collect and own, even if it sits with a third-party provider. The data processors, which are ourselves, are accountable for the data that we store and process on behalf of our clients. So that we understand further, and I was talking from the same song sheet, the key terms in the payroll world: data subject is an employee, the business owner, an authorised contact, etc. Anyone that we hold personal identifiable information for. Data controller is the employer, so the client, yourselves. HMRC, Child Maintenance Service, pension provider, Department of Work and Pensions. Data processor is interpreted as the payroll provider, which is ourselves. The BACS agent that we will use to process BACS processing, our IT provider, and any outsourced HR provider that you may use. The reason why we carried out a data privacy impact assessment at DPIA was because in the jargon, which explains in what case should one be carried out, we are following the rule of, because we evaluate a natural person using automated processing in order to make decisions or have legal impacts on the subject. And that very, very clearly covers what we do as a payroll bureau. In July 2017, we started the GDPR project, and the first step in doing so was to carry out our data privacy impact assessment. And this project has now been completed. The DPIA project has been completed, and it consisted of a full data inventory and data asset register, data flow audit, so following the incoming, internal and outgoing flow of our data, risk assessment of our full estate, that included where we store our data off-site with our IT providers and with the BACS agents. Controls, improvements and procedures were identified, and they have been implemented, or they are going through a process of being implemented. We integrated all the system changes into any new projects which are about to take place, but also made a pro forma in place so that any new projects from there on in would also go under a data privacy impact assessment. And we are going through a process at the moment of informing, training and consulting all stakeholders. That's not only our staff, but that's also clients, and that's any company that we have business dealing with on a day-to-day basis or could potentially hold our data. What is key for the GDPR project is to make sure that there is a firm understanding of the data subject's rights. As a payroll processor, we obviously are processing, holding, collating, amending, distributing personal identifiable information, mainly employees and director information. So here is a brief view of the data subject rights, which is pertinent to everything that we do. The data subject has a right to be forgotten, as be removed from any form of our marketing lists or any form of information that we hold. Obviously, this is after legal requirements to hold data. So if we are required to hold data for 3 years for tax or PAYE services and records, then that takes precedence. The right to be forgotten is after that effect. We are required to store information regarding individual employees, make sure it's accurate, up to date, make sure it's stored and processed securely for specific legitimate reasons. Obviously for PAYE reasons, that's important to have a clear retention policy, the right of access, and for affirmative consent. We recommend that our clients make sure that part of their HR onboarding process has a fair processing policy in place, which clearly states what they are collecting the information for and where it will be distributed. So if you are using an outsourced payroll provider, it clearly states in your fair processing policy that their employee information will be shared with an outside provider, and you may need to identify the contact details for that company within your HR booklets. In terms of what do we do with the data subject's information, well, we receive data, collate it, store and archive it, calculate pensions and payroll and overtime, etc. bonuses. We amend the data when people move house, when they become retired, if they have student loans. This information is amended. We distribute it, so we ensure that information goes back to the client. We may potentially use that information to update Department of Work and Pensions if there's an inquiry, or for tax reasons with HMRC, and obviously we delete the data when an employee leaves the business, although generally speaking the data is held on record for the 3-year retention policy as stated previously. To give clients and prospects a very clear understanding of our data privacy impact assessment, we went through a process of understanding what data do we store, where do we collect, store and process the data, and how is that data protected currently. It's important for us to ensure that our clients are very aware of the data the type of data that we do store. Obviously we collect employee data, and that generally includes name, address, gender, date of birth. Could be things like the employee ID, email address. Sometimes we have to collect bank details. There will be pension information, national insurance numbers, student loans, salary sacrifice, car details. And then on top of that would be additional information, so holiday entitlement, sickness, whether that is contractual, SSP, maternity, paternity dates, paternity leave, notice periods, end of contract arrangements, obviously commission, those sort of things. A lot of that information, as you can see, is actually very personal information. It builds up a very strong profile of an employee, and if it's in the wrong hands, obviously it could be very damaging. The next phase of the DPIA was to identify where we collect, store and process that particular data. Well, the data comes into the business and it's held in various forms, primarily within STAR Payroll Professional, which is the bureau management system and payroll processing software that we use. And information comes in a variety of formats from clients, and it comes in Excel, Adobe, CSV files. We get it in email exchange, so just general words on an email, and also through our portal upload, which is CHAPS. The information is processed by ourselves and also will be processed by a BACS agent. The information is also uploaded onto the various pension portals and AutoPay, which is another form of BACS payment. We obviously have on-site files, and they are locked in secured offices and in secured cabinets. Our data protection policies and procedures, which are currently in place, ensures that the data is protected. And just to highlight what is currently in place, we have appropriate security levels set for staff and IT support, so no one has an access all information. And it's important that we reiterate that the security level is set, which is appropriate for each staff member. We have encrypted storage and transfers and passwords. So the emails are encrypted, HTTPS exchanges take place. The majority of our clients password protect their documents coming into the business and vice versa. When employees and clients ring the office, they are taken through a caller ID security check. So if they fail any part of the 3-point security check, we refuse to speak to them, which is most annoying sometimes. We have a client authorised contact list. So if there is a change of authorised contact within the business, so the person who we deal with for the payroll or the finance manager changes the business, if we are not notified of that change, then we have to get an authorised form from the owner of the business to say who the next employee will be that we will be contacted by and that authorisation level. There is data workflow due diligence testing, so we always are looking at the way the workflow takes place within the business and how it flows out of the business to our clients and vice versa coming in. That is part of our privacy by design process that takes place anyway. We make sure education and training of our staff, and we make sure that our clients are educated and trained on what we require from them to make sure that we can keep our data protection policies up to date and enforced. To give yourself a clear understanding of how your data flows around our business, we're now going to follow the process over the next couple of slides. It will follow the incoming data, where it's stored, physically stored, and the outgoing data exchange. Generally, there's two types of data exchange that takes place into Cox Co. An awful lot of information comes in, and that information doesn't actually contain any PII data, and that generally comes in via office phone calls, people ringing up for queries, wanting to know did somebody get paid last month, and that sort of information. Mobile phone calls we receive, and also some clients still text message us, but the information that comes in via those mediums normally doesn't include any particular PII data. The PII data that does get transferred comes through using the Excel spreadsheets predominantly and PDFs. That can come through from where an employer has collected and collated the hours, commissions, bonuses, overtime, sick pay onto a spreadsheet, or could also include the new starter forms or leaver forms that we ask an employer to fill out in the event of a new employee starting or leaving. And that comes through via our portal, which is a SharePoint portal, email with attachment, or via post. And as you can see on this slide, we've highlighted in red that it could potentially be a high-risk breach. The reason why it could be a high-risk breach if it's not password protected or encrypted, if the attachment is not password protected, if the email is not encrypted, if the post has not got any form of recorded delivery and signed for at the other end, it is obviously open to a breach. And we have recognised this, and it's important that both our clients and ourselves make sure that we follow the rules and the policies and procedures that we have in place to protect the data that we are holding and transferring on their behalf. This next slide covers data storage. Admittedly, it looks rather confusing, but I'm just going to take you through it. So the information that comes into the business is stored on our platform, which is with our IT provider, which is Spider Group, and they are in Bristol, England, and their equipment that they own is in a data house in Newport, so it's well and truly on UK soil. A migration of our platform is planned, and we will be moving to Azure, and that data again will be held within the UK, and that will be our server, our email, and our portal will be hosted by Spider Group again, but using Microsoft Azure. And the reasons why we are doing that is because it gives us a better email encryption facility. SharePoint is going to be migrated, and we will then have a two-factor authentication for sign-in for our clients, which will potentially involve a PIN code going to a mobile facility, and that has to be entered in order to gain access to the SharePoint facility. It gives us faster scalable processing speed, so hopefully should speed up our payroll processing, and we can benefit from Microsoft's up-to-date security penetration tests and resilience testing. E-payslips, they are hosted by Star Payroll, and they use Rackspace in Middlesex in England. So again, all of our data is held on UK soil. Looking at the outgoing data, it's the reverse of what we previously looked at, obviously. Most information is held in Star database and Excel spreadsheets on our internal systems, and the information flows back out via SharePoint portal, email with attachment, and post, although post is actually far and few between now. Again, the same level of high risk can be associated with those PII transfers taking place if the correct processes and procedures are not followed, so encryption, password protected, and signed for by receiver post. We also transfer information to the e-payslip site using HTTPS encryption, and non-PII transfer takes place back the opposite way, obviously with clients, be that phone calls, mobile phone calls, and via email. Once our DPIA initial project was completed, it highlighted a number of improvement measures that could take place to improve the security of the data that we hold and exchange on behalf of our clients. And a project plan was drawn up to implement those improvement measures to make sure that we were compliant by May 2018. And just up and down the project list here, so immediately we informed our clients that we needed them to password protect all their attachments if it contains PII information. So that's what we expect our clients to do naturally, and we protect our password documents as they are sent out. In October, the statement of intent, or a GDPR statement of intent, is going to be announced to our client base, and it will also signify what the phased implementation notice will be at the start of the new year, and what those improvement measures will be and how it will impact our clients, and training will begin. Also in October 2017, the Microsoft Azure migration will take place, and this will help us to be able to encrypt our emails better and start the training process for SharePoint migration. In January 2018, so in a couple of months' time from the date that this was recorded, the SharePoint migration will start. We'll build the new SharePoint portal for our clients and move the data across. Also, we will no longer send non-encrypted emails if it contains PII information. We cannot stop our clients sending information in without using encrypted email, because that facility will only be available on their own servers and by their own IT providers. So we can only make sure that we follow our own processes and procedures for making sure that we reduce the potential or the likelihood of a breach of an email going in the wrong direction. And all our policies and procedures for GDPR will be available on our CHAPS portal. March 2018, hopefully the SharePoint migration will be complete. That means that the new CHAPS portal will be available. Two-factor authentication will be required then to access the portal by clients, and that again will be a phased-in implementation and training exercise for our clients, and all the literature will be sent out to clients so that they understand how to sign into the new portal using the two-factor authentication. By which point they will be well and truly, we hope, used to sending and receiving emails encrypted, and also all documents being sent into the business and sent out to the business will be password protected. By the end of April 2018, the data transfer via encryption, CHAPS only, and the project will be complete. So by the end of April 2018, what we are hoping to have achieved is a new securer SharePoint portal using two-factor authentication in order to gain access. Email exchange will be encrypted, password protected documents only, and what we would like our clients to do from April is to transfer their data using CHAPS wherever possible. So we limit the amount of email coming into the business with attachments. And we're hoping that that is the way that we will move forward and grow the business, using the portal as our main transfer mechanism. So to summarise our GDPR presentation that we gave to our clients, we ran over what our current data protection policies and procedures and how they were compliant, how it currently meets GDPR regulations. But then we also went over what our data privacy impact assessment project contained, and we have completed that initial assessment. We've identified the improvement measures it's going to improve the way that we handle data within the business, and we've created a project plan, and that has a phased implementation starting in October and will be finished by April 2018. So the project will ideally be finished by the 30th of March, ready for a 1st of April completion date and launch date. Obviously, understanding and interpreting the GDPR requirements and regulations sometimes can be a little subjective. So here we've got a couple of scenarios in connection with payroll processing in particular that we took our clients through, hopefully to sort of highlight the differences that could take place and which way it could be handled within the business. So here we have Harry works in the payroll department and sends an email containing payroll information to the wrong recipient outside of the business. Obviously, this could also be a wrong recipient within the business and not necessarily a payroll bureau handling this information. It could be our clients handling payroll information or any sensitive information that contained personal identifiable information. So in the first scenario, the attachment contained name, address, gender, bank details and court order information. The email was sent encrypted and the attachment was password protected. Harry contacts the recipient to ask for deletion and informs the data protection officer. And in this particular scenario, this is the correct course of action to take. While a company carries out their data protection, data privacy impact assessment, they risk assess what is the likelihood of a breach and what would be the impact of that breach should a certain scenario take place. When Harry has informed the data protection officer, then they will be able to use those risk assessments to give them a workflow of what needs to take place. And in this instance, the email was encrypted and the attachment was password protected. So it was the highest level of security that particular company could have had for an email. And they would most likely audit that the email was sent and who to and what date, so that they have a log should anything come out of it. But other than that, there is a very low chance, a low risk of that email being breached and that information, that PII information, going into the wild. In the second scenario, Harry sent the email as confidential with unprotected attachment. The attachment contained total sickness costs in pounds by department. Harry asks the recipient to delete it and does not inform the data protection officer. In this particular scenario, the actual email didn't contain any PII. Therefore, there wasn't break-in protocol. There may be in this particular instance, it might be a confidentiality breach of internal policies of the company, and this comes down to your own internal affairs and how you handle breaches of information going outside of the business containing information, and your own internal protocols that you put in place. And it's really important to make sure, and this highlights the necessity to ensure that your staff are suitably trained on the ethics surrounding email exchanges and what to do in each instance and what is confidential information. This all comes down to your induction and ongoing training within your company. This particular instance, it doesn't breach GDPR. Harry has asked the recipient to delete the information and he hasn't informed the DPO, and again that comes down to whether your internal policies and procedures state that Harry should have informed the DPO of this breach, but there's not actually a GDPR breach that has taken place. In the third scenario, Harry sent the email as normal with a password protected attachment. The attachment contains the names of trade union members. Harry immediately notifies all members listed in the email of his mistake. The trade union membership is an additional sensitive piece of information, and it goes along with sexuality and ethnicity, so it's highly confidential and sensitive. And in this instance, this is a breach of GDPR because the information was not sent encrypted, but it was password protected. But because the PII contains lists of identifiable persons and in particular their trade union membership, this is a breach. Therefore, it should have been immediately reported to the data protection officer, and they would have been able to follow their internal processes and procedures on what to do in this case. And that would have involved informing the ICO of the breach of information, and that has to be done within 72 hours of awareness of the breach, and that would have also been recorded in the audit log. Harry should not have immediately notified the members of his mistake, because again that needed to be from a company perspective, not from an individual employee perspective, and the notification needed to go out to members via the company, and that would have also involved informing them that the email was password protected, or rather the data document was password protected, and what is the likelihood of effect, and also what improvement measures have been taken place to improve that so that it doesn't happen again. The ICO will also make an audit log, and in some circumstances may follow up with an investigation, but it really does depend on the extent of damage, the quantity of data that was let loose into the wild, and also the manner in which it did. But you would need to inform the ICO in this instance, and Harry would need to follow internal protocol, which again comes down to training and education of what is the correct way to report a breach and how to handle that breach internally. So thank you for listening to our GDPR workshop presentation. I hope you found it useful. I hope that the information that we've highlighted and the strategies that we have in place to protect the data that we hold for our clients has helped you somewhat. If you wish to discuss anything further, please get in contact with us. Policies and procedures are available on request, and you can contact us at Cox Co, and particularly myself, on 0117 9323 444, and my email address is tracy@payrollsolutionsltd.co.uk, and I hope that you have a lovely day. Thank you very much.